Ladies and gentlemen, gentlemen and ladies, ladies and gents, whoo! Ladies and gentlemen, we got some talking we gotta do, ladies and gentlemen. Y'all ready? I hope y'all ready, because I just wait, hush! Don't say a word. Okay? Because we already know what you're thinking. Okay, ladies and gentlemen, what's sitting in front of you, and that's going to be back in a second. Let me make sure of something before we go on, because I have to, because it's happened before. There you go. I need the volume. All right, ladies and gentlemen, ladies and gentlemen, what we're doing right here, as a matter of fact, let's go ahead and take care of that now, so that I don't have that as a problem. Okay. Yeah, see, what's happening is there is a communication error. And what's that communication error? It's right here, my dragon naturally speaking. So we're going to get rid of that so we can move on. But don't worry about the music in my background. That's Deborah, and she going to be there for a minute, okay? Ladies and gentlemen, what I need to show you is this. This is the 91 stat 875. Do you know what 91 stat 875 is? Well, you need to start using statutes at large. Get away from them stupid codes, people. I know you might, but stop using it, people. No more using no more codes. Stay away from the stupid code. The code is a trap, ladies and gentlemen. That's how they've been getting y'all in y'all court cases. Y'all keep using these little stupid codes. Look, hold on. Defamation. Consumer Credit Protection Act. Wait a minute. Why did we get to the Consumer Credit Protection Act? Wait a minute. Hold on. Consumer Credit Protection Act? Wait, hold on a minute. Let's go on up here and find out for sure what we're looking at. Hold on. We're going to go all the way up to the top. Because we started from the bottom. Now we're going to make it to the top. Okay? Pay attention. Consumer Credit Protection Act. Oh, it's called the Debt Collection Practices Act. Fair Debt Collection Practices Act? Yeah, this is the Debt Collection Practice Act. Well, it doesn't say Fair Debt Collection Practices Act. We needed to say Fair Debt Collection Practices Act. Because if it don't say Fair Debt Collection Practices Act, then it ain't the same thing. They're going to be just using the Fair Debt Collection Practices Act. Oh, I'm sorry. I apologize. That's right. I know you know what you're talking about. So I ain't gonna. I'm gonna be quiet now. No, you done told me to shut up in your own little way. So I'm gonna shut up, okay? Because I know, that there's a problem. Ladies and gentlemen, I just want you all to understand something, because I know that it's difficult. You thought you knew. You thought you knew. So let me tell you something you thought you knew, because I thought I knew too. Well, I knew better than what they were saying. So let me go ahead and tell y'all how much I know better than what these are telling you people. Now, remember, if anybody else has brought this to your attention, then you should be patting them on their back and saying, why don't you tell EeON? Huh? What the? You didn't tell EeON, folk. Ladies and gentlemen, I wish somebody would have come and told me this. See, this explains to you all the terms in the Fair Debt Collections Practice Act. Because Deborah, the volume and everything is taken care of with it shutting down. We're going to pause you, Deb. Deb, I'm sorry. All right, I'm going to start you from the beginning later. All right, ladies and gentlemen, let's talk for a second, shall we? These are the definitions in the Fair Debt Collections Practice Act. Now, we need to know what a creditor is, and we need to know what a debt collector is. Would you guys like to know what a debt collector is? I promise you, once you find out what a debt collection is, it's gonna blow your mind, because it blew mine. Didn't I blow your mind this time? Didn't I? That's what the Debt Collection Practice Act is telling us. Now follow this. The term debt collector means any person, any person, corporation or otherwise. All right, now I want y'all to pay attention. I'm gonna take y'all away from this for a second, because we gotta venture on over and look at something for a second. So I want y'all to follow me. Is this it? No, this ain't it. Hold on. That ain't it. That ain't the one we're looking for. That's not the one I'm looking for, Chief. That ain't the one I'm looking for either. I think it's this one. Nope, that ain't it either. Hold on, I had it open. Was it this one? Nope, this is the... Oh, it is this one. I'm sorry, y'all. I opened it in a different window. Whew. Thought I missed it. Thought I missed it. Thought I missed it. I want y'all to see what the cult said, because it's important that y'all see what the cult said. Okay? It's important. Impotent. Okay? So let me tell y'all something. The term debt collector means any person who uses any instrumentality. Okay, you seen that a minute ago, right? Whew. Now, we're going to go down to A, B, C, D, E. We're going, oh, there's F right there. Notice what it don't include. Pay attention. It doesn't include any person collecting or attempting to collect any debt that is owed or due or asserted to be owed or due another, to the extent such activities is incidental to a bona fide fiduciary obligation and a bona fide escrow arrangement, concerns a debt which originated by such person, or concerns a debt which was not in default at the time it was obtained by the person, and or concerns a debt obtained by such person as a secured party in a commercial credit transaction involving a creditor. Now that's section F, and under section F is 7, 8, 9. So let's do me a favor, y'all. We got to check something out. Y'all don't mind if we check this out? Because that's what the code said, that the banks are not debt collectors. Whew, man, let me tell you something. Section number 6. Hold on. It's got to catch up to me because, you know, we're doing a lot of stuff here on this computer today. EF. An attorney collecting a debt as an attorney on behalf or in the name of a client. Okay, got you. And, hold on, we got to wait for it to catch up. Oh, look at that. Wait, hold on. Where's the rest of F? And, where's the rest of F? Wait. Bona fide debt originated by such person, concerns a debt that was not in default at the time it was obtained by such person, or concerns a debt obtained by such person to secure party, blah, blah, blah. Wait a minute, hold on. Let's go. Wait, that don't make no sense. Y'all, hold on a second. I just need to show y'all this. I moved my mouse too much. Ladies and gentlemen, here is section F. There is no section G. Where did they get G from? Oh, they didn't. They don't have G here. Oh, what's up, G? Where is G, y'all? Ladies and gentlemen, this court right here. Now, they did the right thing. I want you to see. Got to clear my throat. See that right there? It said, for the purpose of this section, the bank collecting a debt, they ain't a debt collector. And if they receive the, they assume the note, then they ain't a debt collector. Ladies and gentlemen, guess how you get around that? It's not a secured debt. So if they're trying to use the Fair Debt Collections Practices Act, they cannot use the Fair Debt Collections Practices Act as a, pay attention to this because you need to understand this, as a means for using the Non-Judicial Foreclosure Act. Because they're trying to use the Non-Judicial Foreclosure Act, because they're saying it's a secured debt, they have violated the Fair Debt Collections Practices Act. Because it is not a secured debt, it is a personal loan. Ladies and gentlemen, can a bank sell your debt to another party? Yes, common law says that somebody can take your debt and sell it to pay their debt. So yes, they can sell your debt to another party. Are you still obligated under that debt? Yes, you most certainly are obligated under that debt. However, when they use this code to come at you, or when they use any one of the codes to come at you, challenge the code. Challenge the code. The code is only prima facie evidence of so-called law. And then you challenge Congress. Because remember, it is Congress who named what a debt collector is. Traditionally throughout history, a debt collector is anyone who is attempting to collect the debt. But they say the exact same thing. Hold on. Let's go up here. It says the term does not include an officer and employee of a creditor while in the name of the creditor collecting a debt as such creditor. See, what it says is that we're going to protect the creditor. See, the term debt collector, see, they created a term. They didn't create a word. So they define the term is any person who uses an instrumentality in interstate commerce or the mail in any business, the principal purpose of which is the collection of any debt. Oh, that's a shame. According to the statute, banks are not included as debt collectors. Well, hold on. Watch this. I'll be right back. I'm going to pause y'all for just a second, then I'm going to be right back. It's going to be like a second for y'all, but it's going to be a couple of minutes for me. Ladies and gentlemen, your arms are too short. Your arms are too short, okay? Don't put me. I apologize, ladies and gentlemen. What I do have to explain to you is it took me aback when I was going over this information. Because when I looked at the code, ladies and gentlemen, this is the code that the casetext.com has on their website. It's a copy of the code. This code doesn't match up with the statute at large. As I've already shown you, it can't match up with the statute at large. Why? Because this is the so-called official, so-called federal law. Now there's two things. You have the Constitution and then you have federal law. Constitution is not federal law. Constitution is not federal law. You guys keep thinking the Constitution is federal law. Pay attention. Constitution is limitations on the federal government. It is not federal law. It was not instituted by the federal government. It was instituted by the people. It was the will of the people. That's why it had to be ratified. Y'all need to understand the difference. Now that you understand that difference, let's go ahead and understand something. If somebody brings a code against you, I don't care if it's a criminal code, if it's a state code, if they bring a code against you, the code is only prima facie evidence. In other words, it's presumptive evidence. You have to rebut that junk. Just like the court, when they highlighted that the young man bringing in 12 USC 95A and B, you can't bring that in this courtroom, hun. No, look here, son. Take that on out of this courtroom. I don't be bringing that stuff up in here. You bring that stuff up in here again, I'll hold you in contempt. You guys have heard them say, you mention the Constitution, and because people don't use the precise words and they quote, misquote, and all of that. That's the junk. So let me tell you guys how to get around that junk when they say that a mortgage company is not a debt collector. Let's have you get the understanding first. Section 6 talks about a debt collector. Let's slide on over here. Section 6 says the term debt collector means any person who uses interstate commerce or the mail to collect the debt, and that's their normal business. Okay? Or, the last sentence of this paragraph, ladies and gentlemen, the last sentence is the term the term does not include. That's the last sentence, so that's what you want to pay attention to. The last sentence of this paragraph, the term includes any creditor who, now it says notwithstanding the exclusions provided by clause G of the last sentence of this paragraph. Wait a minute, hold on, I done just caught something else. Hold on, I be catching things, y'all. Let's go back up to, that's my girl, y'all. Okay, I'm looking for that exclusion section. Okay, notwithstanding the exclusion in clause F, that shows you how far this junk is off from the actual original code. They ain't received no jurisdiction to be changing it. So why did they change it, ladies and gentlemen? We don't care. It don't matter. They ain't have the authority to change it. This wasn't Congress. Congress didn't put together the code. You guys think Congress did this junk? No, this junk was done by the courts. And because they were rushing to get things done, they made a whole lot of mistakes. We just pointed out 2 mistakes. You guys have no idea. By the way, if it doesn't add up, see, this is not like scripture where you're translating into 2 different languages. This junk is purporting to be directly equal to the legalese in the original act. So, ladies and gentlemen, if there's one mistake, then that throws the whole thing off. You tell one lie, you're a liar. Your mama. Okay? That's just, you see, that's what friends are for, y'all. That's what they're for. They're here to tell you when you're lying, you're lying. When this junk is lying, that's what I'm here to tell you about. Okay? There's a lie, but let's continue. We're going to go to the act. Forget reading it from here. All right, ladies and gentlemen, it says, notwithstanding, in other words, other than, okay, the exclusion provided in this clause of the last sentence of this paragraph, the term includes. So that exclusion works. Ladies and gentlemen, give me a second because I got to answer this, y'all. Hold on. 1 second. Okay, ladies and gentlemen, I was answering a call about the filing of the summary judgment. See, the person contacted the court and they told them all about everything they didn't need to be telling them about. When you're calling the court and asking them what their procedure is, you don't need to give them, well, what are you trying to do, sir? I'm trying to file a summary judgment petition in my case. Well, what's your name? Excuse me. I'm not here to talk about my case. I'm here to talk about what are your procedures. I don't need you to do an investigation. I just need you to tell me what the procedures are. Well, I tell you what, since you are refusing to answer my question, and I do appreciate it. I know your job is hard and you're there all day long doing the same stuff over and over again, answering the same questions over and over again, and you answer everybody else's questions, but you want to sit up here and single me out and not answer mine. Why don't you put me on hold and get me that supervisor so I can talk to them about your conduct? Just that simple. All right, ladies and gentlemen, I want you guys to pay attention to something here because it's very important. It says the term includes any creditor who, in the process of collecting his own debts, uses any name other than his own, which would indicate that a third person is collecting or attempting to collect such a debt. For the purpose of Section 808(6), such term also includes any person who uses any instrumentality in interstate commerce and or the mails or any business, principal purpose of which is the enforcement of the security interest. The term does not include. See, that's why they say notwithstanding G. The term does not include this. See, because banks use debt collection agencies to collect their debt, the debt collection agency is a debt collector. A servicer is not the original creditor. Doesn't matter if they represent the original creditor. Go back and look at the servicer. Their name is on the document. Now, this says it doesn't include them. Ladies and gentlemen, let me prove to you that it does. You don't mind? Okay, I don't mind. See, because it says the term does not include any. So let's find out what the term does not include. Because when we go to term does not include, we can't start with all of this. That don't make no difference. We're going to go down to G. We got to find out what the term does not include. Okay. See, it still gives us the any. Okay, so now we got what the term does not include. Ladies and gentlemen, the term doesn't include any person collecting or attempting to collect a debt owed or due or asserted to be owed or due another to the extent of such activity is incidental to a bona fide fiduciary obligation, trustee, or a bona fide escrow arrangement, escrow trustee, or concerns a debt with which was originated by such person, or concerns a debt which was not in default. Pay attention. Concerns a debt which was not in default at the time it was obtained by such person, or concerns a debt obtained which was secured by a secured party of a commercial credit transaction involving a creditor. Ladies and gentlemen, let me tell you so that you don't have to look any further, let me tell y'all what y'all need to do. I'm sorry, this is Dennis Edwards, y'all. Pay attention right here so you'll see the loop around. Any any debt which was not in default at the time it was obtained by such person. Well, hold on. Concerning any debt which was not in default, then it's not a debt collection. But hold on, which was not in default. However, it's now in default. Pay attention. Any debt which was not in default. So that lets us know if it was in default, then they're a debt collector. Well, now that they're in default, they're a debt collector. What do you mean? What are you saying? This doesn't say that. Oh, yes, it does. Any person collecting or attempting to collect any debt owed. Ladies and gentlemen, that's any debt owed by someone who has a debt that was not in default at the time it was obtained. Well, it's in default now. If a debt is in default, let's find out about a debt being in default. Y'all don't mind? I don't know what section it is, so I'm going to have to find it this way. We got default, so we're going to go up. Tonight, rock is all night. Okay, anyway, the term creditor means any person who offers or extends credit creation of a debt or whom a debt is owed, but such term, again, a debt being owed, a default is not a debt, but such term does not include any person to the extent that he receives an assignment or transfer of a debt in default, solely for the purpose of facilitating collection of such debt for another. They're not creditors anymore, ladies and gentlemen. Now, hold on now. Want to make sure you understand, they're not debt collectors either. Okay? They're just collecting a debt. And they're not just collecting any debt, they're collecting a default of a debt. And because that's all they're doing, section number G, here it's going to be section number F, concerns a debt that was not in default. Well, if they got it, it's not in default, and it's not in default, then they're not a debt collector. But once it goes to default, guess what they do? They're not a creditor anymore. Wait, hold on. Y'all don't understand. Rock in all night. Okay, apologize. That's Dennis Edward, ladies and gentlemen. Okay, pay attention. The term creditor means any person who offers or extends credit, creating a debt, or to whom a debt is owed. But such term, creditor, does not include any person to the extent that he receives an assignment or transfer of a debt in default, solely for the purpose of facilitating the collection of such debt from another. That person who is obtaining this, who received it by way of assignment or transfer, that means the servicer. Ladies and gentlemen, the servicer is a debt collector. Hold on. You didn't understand? The servicer is a debt collector. Hold on. Let me make sure. Because, see, sometimes when I speak, people don't understand me. Because I be talking English, and they be talking that other stuff. Debt collector means any person. So let me explain to you what a servicer is. A servicer is not a creditor. And because your mortgage is... What is that? Pay attention. You got to pay attention, y'all. Since the owner of your mortgage, since the owner of your mortgage-backed security, since the owner has transferred, pay attention, and it's a mortgage-backed security, that means they don't know who the owner is. When the servicer is trying to collect on behalf of the owner, and the servicer is the one who's foreclosing on you, and they're foreclosing on you through the trustee, and they're saying it was at the request of the owner, well, let me see that request. I have a right to see that request. Ladies and gentlemen, once they pull the mortgages, y'all need to pay attention. Once they pull the mortgages, they don't know who the owner is. They don't know who owns 51%, because there's no agreement between the owners that the one owning 57% will handle all mortgages. That's why they created MERS, because there's so many different owners. Ladies and gentlemen, there are so many different owners, but the creditor, the actual creditor, is never the one who's kicking you out of the house. It's the trustee. And he's only saying that he's acting on behalf, pay attention, he's only saying he's acting on behalf of the original owner. He is not acting on behalf of the original owner. He's acting on behalf of the servicer. The servicer is giving him that information. The servicer is not the creditor. The servicer is not the creditor. Ladies and gentlemen, the servicer is not the creditor. Pay attention what a creditor is. It's not a person who receives an assignment or a transfer of a debt in default solely for the purpose of collection. Wait a minute. Do you know that a creditor isn't even a person who receives an assignment of a debt? They're not even that person. The assignment, the person who receives the assignment is not the creditor. They're not the owner of the debt. They're not the holder of the debt. Even when you see that someone else has purchased the debt, you say you purchased this debt. I don't see no proof that you purchased this debt. Well, we have this document right here. Document from whom? Man, this is a mortgage-backed security. They don't own this debt anymore. Once they converted this to a REMIC, they're not the owners anymore. What are you talking about? The moment you brought this into a REMIC, there are multiple owners. Hold on. I can't stop, y'all. REMIC. Yeah, that's my part with multiples. Hold on. I know it's a P. Don't worry about it. Let's get rid of that. Take care of that. Don't worry, but don't ignore me. What you talking about ignore? I know. Come on now. Give me my I. Get rid of that A. Lord have mercy. Hold on. Ain't no apologies, bruh. Okay. Under California law, multiple entities can foreclose on a property. Ladies and gentlemen, under California law, multiple entities can foreclose on a property. Here's the only problem. Okay? Trustee, mortgagee, beneficiary, and any of their authorized agents may initiate foreclosure proceedings. Here's what you guys need to understand. In order for the beneficiary to receive that, the beneficiary has to be identified. The beneficiary will never be a bank. What are you talking about? It says right there, name of the beneficiary. Ladies and gentlemen, y'all need to pay attention to me. The beneficiary loses the rights as a beneficiary the moment they do a mortgage-backed security. Y'all don't understand that, do y'all? Y'all need to pay attention. The moment they do a mortgage-backed security, it gets pulled in with other mortgages, meaning that there are other owners. That means the beneficiary has changed. The beneficiary don't have no authority no more. Beneficiary has changed. Why? Because the beneficiary has sold its rights. Mortgage-backed securities, ladies and gentlemen. I know ain't nobody said that. Don't worry about it. I'm telling it to you now. Okay, we ain't got no time to be sitting up here figuring stuff out. I'm just gonna give you the information. Okay, y'all sit up there and go fish it and get it together. I guarantee you that the moment they convert it into a mortgage-backed security, it has multiple owners. Watch this. We're gonna do a Google. Oh, you ain't been to Google in a while, mother. And when last time you went to Google, no, you didn't want to stay there. Ladies and gentlemen, I'm gonna be done with all this by 5 o'clock today. I've been working on an appeal today. You know what, ladies and gentlemen? Leela James, can you tell them about falling in love? Okay. Real estate mortgage investment conduit is a vehicle to pool as individual securities. REMICs can take several different forms. Okay, ladies and gentlemen, let's talk about a REMIC. Do you guys mind if we go to Investopedia? Because you guys, those of you who definitely have, dang it, how do they do it? They give you the series for the mortgage-backed security. They say in series this, and who is that company? Deutsche Bank is very good at doing that. Deutsche of America. What is a real estate mortgage investment conduit? A REMIC. Okay, need to understand. Or debt instrument to pool mortgage loans together and issue mortgage-backed securities. They bring it together. Now there are multiple owners. Ladies and gentlemen, go back and take a look at your deed of trust. You just need to trust me on this, please. Go back and take a look at your deed of trust. It shows that the beneficiary is such and such, such and such. But the moment they take your real estate mortgage and they invest it into a conduit and they pull it together, that special vehicle that they just created got all them inside of that vehicle like them clowns at some little stupid arena in the middle of a circus. And they all jumping and piling inside that vehicle. You don't know who's driving. You don't even know who's in there. Too many people in there. Well, that's what's going on with mortgage-backed securities. The owner becomes too many people. The owner is the beneficiary, ladies and gentlemen. Go back and take a look at your agreement. You made the lender the owner, but the lender has sold their rights when they pooled the mortgage. Don't take my word for it. All you got to do is do the research. I know the right person is going to hear what I just said, and they're going to take that and they're just going to ram it right on up and make them like Shaka Zulu's captives, you know, poles and everything. REMICs are complex. I thought it was a simple vehicle. Didn't you just tell me that it was a simple vehicle? See, a special vehicle, purpose vehicle, that's all it is. So why are you going to say it's complicated after you just said it was just a vehicle? It's a complex investment that generates income for issuers and investors. Mortgage pools are generally broken up into tranches, repackaged, and marketed to investors as individual securities. Ladies and gentlemen, let me do it for you. There is no beneficiary. Nobody can order the trustee to do anything. All of these individuals have to come together regarding your one particular issue, and they have to say, okay, yeah, go ahead and foreclose on that mother. And they ain't doing that. The servicer is doing it. Ladies and gentlemen, I don't care about anything about an assignment. There are too many owners. The servicer has to prove that those owners approve of them doing that. So, ladies and gentlemen, you got a foreclosure going on. What do you have to lose? Excuse me, Your Honor. I don't believe them. What are you talking about? Well, I don't believe that they got the approval of the beneficiary. Do you know how many beneficiaries there are on this deed of trust? Your Honor, this thing was pooled. Here's the proof. Get proof that it's been pooled. Call the bank. Tell them you need to know who the securitization trustee is. Ladies and gentlemen, the securitization trustee is the party who oversees the pooling of the mortgages. It's usually USA Bank or JP Morgan Chase. Sometimes it can be an individual. But guess what? I know some of you are like, man, what the? How does he know that? Ladies and gentlemen, technically nobody can be foreclosed on with this information right here. And you add it to that package that I created. Look, I can't give you everything at one time because I'm going to be hey Gladys, ladies and gentlemen, home alone. I felt like this so many times, and so when I was just sitting at home and just thinking and minding my own business and not wanting to be bothered with anything or anybody, this was the song I played over and over and over again. This song it's written by Babyface, and it's from the album Just For You, which most of the songs on the album were written by Babyface. And all I can tell you is Babyface and Gladys Knight coming together, perfect combination. Hey Gladys, love is gone. I'm gonna have to put you on hold. She's gonna talk about holding on and on. Oh, y'all don't believe me? I'm gonna put her on hold. On and on. Okay. And you can't let go? All right. We're gonna let Gladys hold on for a minute, ladies and gentlemen. I got something I need to tell y'all. I put you guys on pause earlier. Why? Because I had to walk away and figure out how to present the information to you, because I knew the information, I just didn't know how to present it, and I wasn't sure. Because looking at it where they want to define what a creditor is and what a debtor is and then what a debt collector is, again, we're bringing up the issue about debt collector. Don't bring up the issue about debt collector. Bring up the issue about the creditor. They can't represent the creditor because they need the creditor's permission. There is no power of attorney with this agency to represent the creditor. They have a power of attorney from the original beneficiary, but that beneficiary is no longer the beneficiary of this trust. What are you talking about? Well, this mortgage has been pooled. Here's the name of the securitization trustee. A securitization trustee is only assigned, hold on, let me show y'all so that we don't get too far off. All right, I just put securitization trustee and I may have messed up because of my mind is racing right now trying to bring this across in a way to which many people will understand it. Thank you for securitization. Securitization is their word. They created the word. They made it up. Okay, securitization trustee issues, okay, and allows for loan modification only. Okay, related pool are allocated first to any. So we'll go there in a second. What is a securitization trustee? Mama, what's a securitization trustee? That sounds like a stupid word. Securitization indenture trustee means United States securitization indenture trustee means the trustee or collateral agent that holds a security interest in assets on a dang it, I forgot what SPE stands for, y'all. To secure a debt obligation of the SPE incurred in the financial purchase loans. Okay, dang it. Special something. Okay, give me 1 second. Let's find out what that is. Sorry, I got to get the SPE because it don't. It's a special. God. SPE. Come on, SPE. 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 Where SPE? SPE. It says SPE if the borrower fails to maintain its status as a special purpose entity. I told you it was special. Anyway, breaches any representation or fails to comply with any warranty or covenant set forth in section blah 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 dera. Okay, pay attention, ladies and gentlemen. I need you guys to understand. The securitization trustee means the trustee or collateral agent that holds the security interest in the assets. And the special purpose entity of a special purpose entity, meaning you, to secure a debt obligation of the special purpose entity incurred and finance the purchase of loans. Pay attention, ladies and gentlemen. The securitization trustee only handles that junk which is being traded. Examples of securitization indenture trustee in a sentence. The issuer may and intends to assign all of its rights to the securitization trustee on behalf of the securitization note holders. Note holders. An originator consents to any such assignments. That means you consent. Ladies and gentlemen, here is the point. In order for them to foreclose, it is not the securitization trustee who gets to make that determination. The securitization trustee is not the creditor and cannot act on behalf of the creditor to foreclosing your property. It has to have the authority from the originator, the beneficiary. Well, the securitization trustee is not the beneficiary. What you say, boss? Securitization trustee is not the beneficiary. You would never assign your beneficiary rights over to somebody else saying, take care of that for me. That's a trustee. Securitization trustee is not a beneficiary. You would never sign over your beneficiary rights to a trustee, a fiduciary. Why would a beneficiary assign their rights to a trustee? They never have done that. They cannot prove that they have authority from the note holders, because there are too many of them. There are thousands of them. Ladies and gentlemen, do you know how many companies invest in securities? Do you know how many companies invest in securities, in mortgage-backed securities? How many banks invest in mortgage-backed securities? How many governments invest in mortgage-backed securities? How many foreign banks invest in mortgage-backed securities? How many individual traders invest in mortgage-backed securities? There are too many title holders for them to have gotten approval from the beneficiary. See, the issuer may and intends to assign all rights to the securitization indenture trustee on behalf of the securitization holders, and the originator consents to such assignments. That's okay. They can assign all of its rights to the securitization trustee, but I need y'all to pay attention. In order to foreclose, and they have a right to foreclose, you can't give that to a trustee. See, the trustee has to get that right from somebody. So usually the trustee who's foreclosing on your property is not the securitization trustee. No, it's the trustee assigned by the servicer. Securitization trustee is somebody completely different. It's usually a corporation. Corporation can't foreclose on you. What do you mean a corporation can't foreclose? Because they would have to assign that duty to someone. Corporations ain't gonna assign that because they ain't gonna take the hit for it. So let's see if I can break this down in simpler terms. Those of you who are going through foreclosures, if you're with any of the big banks, doesn't matter if it's a refinance or otherwise, you need to understand, you need to contact and find out who the securitization trustee is. If they have a securitization trustee, don't worry about them claiming that the securitization trustee has the authority. Where's the proof that he has the authority? Oh, no. They don't have the authority to change beneficiaries. No, you don't understand. I did give authority for them to do the assignment. They can do assignments. I did give the authority when I signed the paperwork. But you guys sold the note, and thus the beneficiary changed. And when that beneficiary changed, that beneficiary didn't give authority for this. That beneficiary didn't come in. See, the new beneficiary, hey, we accept everything. But what you didn't do is you didn't notify me of the new beneficiary selecting a new beneficiary, because it can't happen. You see, the new beneficiaries are involved in a pooling and servicing agreement. And in order for anything to be done, all of the beneficiaries have to be notified, and they all would have to have agreed in advance. That hasn't happened. Okay? And they can't prove it even if it did. It doesn't matter how many documents they bring in there, because you have a right to cross-examine those individuals if you need to see if they actually agree to this. Doesn't matter how many documents that they say is certified and all that. No, they don't have a single document showing that these beneficiaries gave this trustee, this servicer, the authority to foreclose on their behalf. That's where people were winning before, but what happens is, I couldn't understand the argument in the past. I heard people talking about they don't know who the owner is. They kept saying they don't know who the owner is. Well, ladies and gentlemen, that's absolutely right, because under the Fair Debt Collections Practices Act, and this is a debt collection, because they are receiving authority from the so-called original creditor. The original creditor has changed to too many creditors. That's why they added that in there, because there are too many creditors. So when they go collecting that default and trying to foreclose on the default, that's where they've messed up. Because in order to foreclose on the default, they need the authority of all of the individuals. The trustee could be whomever the trustee wants to be, but the beneficiary has to give the trustee the authority to do what the trustee is doing. Did the beneficiary give the trustee the authority to do that? Well, they say they did. Well, where's the proof that the beneficiaries, because now there are many, gave them the authority to do that? Ladies and gentlemen, let me tell y'all something. I don't like advertisement. Get out of here. I'm gonna get off of your site because y'all want to advertise. Get on out of here. I don't care about your little stupid cookies. Going to want some cookies? You better go talk to that stupid monster. All right, hold on. Do irregularities in the securitization of mortgage void the latter? The trust deed is assigned to a new set of beneficiaries who substitutes blah blah blah. That's what we're interested in. Is the assignment. Ladies and gentlemen, it may say one name, but that's a lie. The assignment will say one name, but the actual process, pay attention now, the actual process is once it is pooled, then pay attention, once it is pooled, there are many owners, not just one or two. Facts. A homeowner obtains a mortgage secured by a trust deed on their property. The homeowner later defaults on their mortgage. The mortgage holder transfers the mortgage to a securitized trust after the closing date by which mortgages are to be transferred to the trust under the pooling and servicing agreement. Okay, understand. There is a date, a cutoff date. If they don't do it by then, it's an invalid transfer. Anyway, the trust deed is assigned to a new beneficiary who substitutes the trustee. And the substitute trustee then issues a notice of default. Ladies and gentlemen, pay attention. This is where they make the mistake. This is what I was talking about. See where it says the trust deed is assigned to a new beneficiary? Ladies and gentlemen, that new beneficiary is thousands of people. So when did those thousands of people agree to substitute the trustee? Where's that proof? Let me see it. It'll be in a pooling and servicing agreement, ladies and gentlemen, because that's what they created. A pooling and servicing agreement. Okay, but if that's the case, then the beneficiaries would have to agree to substitute the trustee and to allow the substitute of trustee to do a notice of default on the homeowner. The deficiency remains uncured and the substitute trustee non-judicially forecloses. Claim. The homeowner seeks return of their property, claiming that the foreclosure sale was void since the assignment and substitution occurred after the closing date of the mortgage holder's securitization of the trust into the PSA. I gotta go, pooling and servicing agreement, sorry. And thus the trustee did not have the authority to foreclose. Counterclaim. The mortgage holder claims the foreclosure is not void and the owners has standing to challenge them due to the perceived irregularities in the assignment of substituting, since the homeowner is an unrelated third party to the assignment and substitution. See, that's what they say. You're a third party, but actually that's not true. You need to understand this. That is not true. We just talked about how the homeowner agrees to the assignment. So he is a party to the assignment. It is by his agreement that the assignment has taken place. Only because they don't have somebody like me arguing this stuff is why this junk goes on. So let's see what California said. The California Stupid Court of Appeals, yes, the Court of Appeals in California are all stupid, every single one of them. The foreclosure sale is not void since any procedural irregularities in the trustee assignment and substitution of trustee makes them voidable but not void. Okay? Only by the mortgage holder or homeowner as a non-participant lacks standing to challenge them. Ladies and gentlemen, again, you must understand something. All of you need to understand something. You are the one that gives authority for the assignment. So you don't lack standing to challenge the assignment. This is the junk they keep coming up with. So we're going to do it again. Get on out of here, irregularities. I went to Investopedia. So we went here. Let's see. Yeah, we're going to go here. That's where we went, I think. What is securitization trustee? I want y'all to understand. This is the general understanding. Securitization trustee means U.S. Bank National Association. Yes, usually U.S. Bank is, this is an example, but U.S. Bank is usually, or Chase Manhattan. A national banking association in its capacity of indentured trustee under the securitization indenture and its permitted successors assigned in such capacity. Securitization indentured trustee, I'm looking for the part where, oh God, this ain't the one I was looking for. Okay. All right. Issuer may and intends to, you are the issuer, ladies and gentlemen. The issuer may or intends to, get out of here, assign all of its rights to the securitization trustee on behalf of the securitization note holders and originators, consents to such assignment. Okay? So watch this. I'm thinking, let's do this right here. Let's go ahead and get you the definition so you understand. Come on now, hurry up, Google, Smoogle, Frugal. Now this is my girl Gladys. We're gonna come back because she's gonna help us understand something, y'all. To learn to live without the one you love. To learn to live without the one you love. Okay? You know, sometimes you walk the flow and you watch the walls so they don't close in on you. In a mortgage loan, the mortgager is a party receiving the loan and the mortgagee is a party offering the loan. Ladies and gentlemen, your home is not a mortgage. Your home loan was not a mortgage. You did not receive a home. You received a loan. It was not a mortgage loan. Hold on. I want to do this real quick because yeah, let's do definition. Okay, let's do definition so that you guys will see what the definition is. What is a mortgage? The term mortgage refers to a loan used to purchase or maintain a home, land, or types. Oh, look at that. Hold on. Legal. Uh-oh. Did I put a K twice? Yes, I did. Sorry, I'm not looking because I is tired. Been up since 5 o'clock this morning. It's 4 o'clock in front of this stupid computer. A mortgage involves a transfer of interest in land as security for a loan or other obligation. A mortgage involves the transfer of an interest in land as security for a loan. Yours was not security for the loan. Go back and look at the situation, how it occurred. Now, this is coming from Cornell Law. A mortgager is the party transferring the interest in the land. A mortgagee is a financial institution, is providing a loan or other interest given in exchange for the security interest. You didn't receive that loan in exchange for a security interest. You received that loan in exchange for your credit worthiness and your job history, because they wanted to make sure you were going to pay back that loan, so they checked your job history and your credit worthiness and your credit report. Go ahead. Go ahead and take a look, people. All of you who sat up there and received these loans, you did not receive a mortgage, because a mortgage would require you to have owned the land before you got the loan. It is not a mortgage, ladies and gentlemen, and thus it is not a mortgage-backed security. The whole mortgage-backed security thing is a fraud. Okay, now, hold on. We're going to keep the change. This is Morris Day, y'all. Now, assignment of mortgage. This is a CFR, Code of Federal Regulations. Of course, the government would regulate this. Oh, go to sleep, Morris. Sorry, I thought he was going to get into one of his songs. Assignment of modified mortgages pursuant to 230 National Housing Act, HUD, may accept an assignment of any mortgage covering a 1 to 4 family residence of the following requirements. Okay. Assignment pursuant to the National Housing Act, notwithstanding the provisions, the commissioner shall, upon application of a mortgagee, approve the assignment of the commissioner of any mortgage issued pursuant to this. Ladies and gentlemen, they don't just do assignments because they feel like it. It's a three-party contract. Because it's a three-party contract, assignment of mortgage insured pursuant to 247. Ladies and gentlemen, all government mortgages are insured. Shh, shh. And remember we told you about 6 months? After 6 months, they charge it off. There's your 180-day mark. Says if the mortgager has been in default for 180 days. We just talked about assignment. We just talked about defaults. We just talked about them getting their credit after 180 days. Automatic. All right. Now that you guys down by the sea, y'all. Okay. Now that you guys know about assignments, okay, discharge and assignment of recorded mortgage. Instrument acknowledging assignment and satisfaction of such mortgage, signed by the mortgagee and the mortgagee's duty to authorize attorney. Okay, ladies and gentlemen, what you must understand, it is a three-party agreement. You are the one who authorizes the banks to foreclose. Wait, an other party lawfully authorized to act on behalf of the mortgager. An assignment of mortgage upon real property. This is Florida, the Sunshine State. No, it ain't. California's the Sunshine State. What you talking about? Florida being the sun? Sorry, ladies and gentlemen. And then we're going to go to the case text. Under the boardwalk. Down by where? By the boardwalk, y'all. You know, there is very little beach going, because I haven't been to the beach. When was the last time I went to the beach and decided to, as Hank would say, put my feet in the sand? I don't know. All right. I really don't know. I used to go to the beach all the time, but now that I am here, I'm so far, I'm about 60 miles from the beach, and it's just, I don't have that in me right now. Hey, hello, is anybody out there? Can anybody hear me? Hello? Hello? Lionel Richie. And hello? I've been along with you inside my mind. A mortgage or separate instrument. Come on now. May provide for an assignment of rents of real property or an interest therein as security for repayment of the indebtedness. If such an assignment is made, the mortgagee shall hold a lien on the rents, or a lien created by the assignment shall be perfected and effective against third parties upon recordation of the mortgage, a separate instrument of public records, and the county of the real property is located according to the law, unless otherwise agreed in writing by the mortgagee and the mortgagor. Unless otherwise agreed in writing by the mortgagee and the mortgagor, the assignment of rent shall be enforceable upon the mortgagor's default and written demand of the rents made by the mortgagee to the mortgagor, whereupon the mortgagor shall turn over all rents in possession. Ladies and gentlemen, I used to do properties, and this is exactly what California requires. The assignment is the assignment. You give authorization to the assignment. This is a three-party agreement. You, the trustee, and the beneficiary. Are you the lender and the servicer? That being the case, they need your permission. They cannot just do an assignment just because they feel like it. What you all don't know is the paperwork you signed at closing is where you give authorization for the assignment. So you are a party to the assignment. That's all I'm trying to prove to you. Upon application of the mortgagee, the bank, or the mortgagor, you, in a foreclosure action, notwithstanding any asserted defenses or counterclaims of the mortgagor, you, a court of competent jurisdiction pending final adjudication of any action, may require the mortgagor, you, to deposit the collected rents into the registry of the court. Oh, look, there go that registry of the court again, Chris. And such other depository as the court may designate, so that they can collect the interest. However, the court may authorize the use of the collected rents before deposit into the registry of the court, or the deposit for all these other issues. Ladies and gentlemen, what you just need to understand here, this is Florida, but what you need to understand is when they came up with this statute in Florida, it was designed for one reason only. To let you know that an assignment, the mortgagee may assign or transfer any mortgage made to he or her or him or person to whom the mortgage may be assigned or transferred, may also assign or transfer it, and that person and or his or her assigns the subsequent assigners may lawfully have, take, pursue the same means and remedies with the mortgagee as they lawfully have, take, pursue. Here's what you need to understand. This whole agreement only is permitted if it's in the contract. There are three people. Pay attention. There is no law of assignment, ladies and gentlemen. They don't automatically get to assign their interest to whoever they want. It's an agreement. And because it's a trust agreement, it's an agreement. It's an agreement in writing. They don't get to do whatever they want. Now, if it was just a basic handshake, then yeah, I could sell this an IOU. I can give this to whomever I want, as long as they have this operates as a site bond. What's that stupid bond called? A bearer bond. Whoever owns this, whoever has it, that's them. They got it, Ladies and gentlemen, just so you know, I promise you, do your research on it, that you are the one who gives the assignment. Just call the bank and ask them, hey, I gave you guys permission to do the assignment, didn't I? Can you tell me where I can find that in our paperwork? Our deed of trust? All you got to do is find it. Once you recognize that you are the one who participated in the assignment, now you become a party to the assignment. Now you can challenge the assignment. Doesn't matter. I gave them permission, but I didn't give them permission to do all this bull. I didn't tell them they could assign this to 100,000 people. Well, then fine. If that's what I agreed to, where are these 100,000 people? And how are they going to be foreclosing on my property? I don't see nothing signed by 100,000 people talking about they want to foreclose on my property. Oh, no. They didn't give them no permission. Go ahead. Show me the permission. Show me where is the permission? They got it from all these people. Show it to me. And then keep copies of those contracts, ladies and gentlemen. Keep copies of those pooling and servicing agreements. Because I promise you, because of how cheaply stupid they are, they have missed a lot of boats. Yes. I know people gonna hate me, but that's all right. That's all right. NWA, mother. Okay. Hey, ladies and gentlemen, I'm gonna ask that y'all have a good day, and we're gonna let Lionel take us on out of here. Hello. Okay, I know it ain't me you're looking for. These are all the browsers I got open, ladies and gentlemen. I promise you, there are at least 12 browsers. Woo-wee, a lot of browsers down there. All right, I gotta go. Y'all take care. I was out of here. We ain't playing no more. It won't. George Benson, The World is a Ghetto. Nah, we're gonna let you go with that. All right, take care, everybody. Gotta go.